No, no, it's fine. Is court ready to start? Courts rise. Appeal in the matter of Recovery Partners GP Ltd and another, and Rudhadze and others. Part heard.
Yes, my lords and my lady, the last case we looked at yesterday was the decision of Mr. Justice Voss in Kidia. I don't want to go back to that, but there was one further point that I ought to have picked up from something Mr. Weisselberg said. In his submissions yesterday, he suggested that one didn't need to worry about that case. It was different because there was clear evidence there as to the market rate for commission in that type of deal. And he referred in support of that submission to paragraph 95 of the judgment, which is the paragraph that I showed the court yesterday. Just to pick that up, in that paragraph, there is no suggestion that there was any expert evidence of the market rate. There don't appear to have been any experts called at all. The judge in that paragraph based what he said about rate on some factual evidence. The only point he mentioned was that being close to the figure that the experienced Miss Luxembourg had negotiated. She, if you remember, was acting for the non-defendant agent. She hadn't given evidence at the trial. So insofar as there was evidence of a market rate here, that doesn't appear to have been anything more than we have in this case, a deal that was negotiated that formed part of the facts underlying the case itself. And in that case, the judge didn't even have the relevant witness, the individual as a witness, in front of him. I should say something about Gray. And the first thing I say is that it's actually a bit of a red herring in this case. In Gray, when it came to assessing at what level the allowance should be, which was, of course, already obiter, because it already decided there wasn't going to be an allowance. But there was only one piece of evidence that was relied upon by the defendant, which is the evidence of a Mr. Ward, who the first instance judge said at paragraph 212 of her judgment had no particular expertise, and of whose evidence elsewhere in the judgment at paragraph 62 she had been critical. So the judge rejected his evidence as any sort of reliable marker for the allowance, and that was it. There was one potential piece of evidence that was rejected. So there was, in fact, no evidence for the judge to rely upon at all when it came to decision. And that, we say, is different from the present case, where there were various pieces of evidence, as noted by the judge herself. And I'll come back to what they were. As to the decision of Gray in the Court of Appeal, which you probably don't need to turn up again, but if the court wants to do so, it's in Authorities Bundle 3 at tab 28. As was recognised yesterday by Mr. Weisselberg, what is said there about what evidence or pleading is necessary is obiter, as recognised at the beginning of the paragraph 239. But in any event, the whole thrust of that paragraph of the Court of Appeal's judgment is that the judge in that case could not be criticised for not going further and identifying another basis for the allowance, but nowhere does it say that the judge would have been wrong to do so if she had thought that that was the appropriate thing to do in that case. Indeed, in the final part of the paragraph, the Court of Appeal said that there may be cases where it's appropriate for the judge to take the initiative in that way. So if anything, what that decision shows is that these sorts of matters, for example, assessing what weight to put on the evidence or what counts as good evidence, what is sufficient to grant the allowance, are really matters for the trial judge. Mr. Weisselberg also referred to the Singapore case of innovative corporation. And again, I don't think we have to turn it back up, but for your note, it is in Authorities Bundle 4, tab 36. And that, I say, is difficult. It's difficult to see how that is helpful to the court in this case at all. We've dealt with it in our skeleton argument at footnote 4 on page 107 and at paragraph 13 on page 109. There, an equitable allowance was refused in principle. That was paragraphs 132 to 133 of the judgment. Mr. Weisselberg showed you 132 yesterday. So again, what was said about quantification or relevant evidence and so on was again obiter. And we've also explained in our skeleton argument why none of that's very helpful anyway, because the facts are very different. What the judge did was run through a number of ways in which it had been said remuneration should be calculated based on quite complicated expert evidence, including according to the CAP-M formula and so on. He just said that was entirely inappropriate. But that's just, those sorts of points just don't arise in this case. The point Mr. Weisselberg seemed to rely on this case for yesterday was not actually in that section at all. It was paragraph 132, which was the primary ground for the judge refusing the account at the allowance as a matter of principle. And it was held that it was not an appropriate case to grant an equitable allowance based upon the defendant's conduct in that case. And that's not a point taken by the claimants in this appeal. I don't need to say any more about it. As I've already explained, there's no challenge in this appeal to the judge's determination of what the law in relation to equitable allowance is. In order to remember, I showed you paragraph, I think it's 372 of the judge's judgment yesterday, which isn't challenged in the grounds of appeal, nor is it challenged whether the facts that she found were sufficient in law for her to grant an equitable allowance. The appeal is all about whether she was right to be able to find those facts or to rely on them for this purpose. My next subheading was authorities relating to the pleadings. And unless the court wants me to go to them directly, I was intending again to take them quite briefly in the same way as Mr. Weisselberg took them yesterday without going to them in detail. And in any event, we say that the points here were sufficiently pleaded and argued, such as these really are not in point. And I'll come to the pleadings and the submissions shortly. But in terms of the authorities on pleadings, we've set out our position on the cases at paragraphs 17 to 19 of our skeleton argument. And the high point really for the claimants is the Al-Madani case, which the court may be familiar with. But it was a case about an accident at work. If the court wants to turn it up, it's authorities to tab 17. And the court was engaged in a factual inquiry as to the cause of the accident. In particular, who placed a roll of foil on a machine which subsequently fell off and injured the claimant. And the claimant had a case that it was a particular individual, a Mr. Brake. And the judge said that it wasn't him. It was another unknown person, what became known in the case as the third man theory. But the person unknown case hadn't been pleaded or put to any witness. And the Court of Appeal said that wasn't open to the judge. So it was a case that was concerned with the primary factual position and what had happened in relation to the accident, principally who had placed the roll of foil there. It was something on which the claimant had a pleaded case, which it had to establish for the claim to succeed, and the judge found that factual case failed. It wasn't open, the Court of Appeal confirmed, for the judge to say, well, there were other facts that had not been pleaded or pursued, that would have given rise to liability, and therefore he found that there was liability. And that our adversarial system doesn't allow that is not surprising, but that is not this case. We're not concerned with the judge on a frolic of her own in relation to primary findings of fact, or a factual case theory, or in any other sense, what happened. Mr. Weisberg also briefly referred on the same theme to the Satyam and Burton case and to the Sainsbury's case in the Supreme Court, neither of which really take things any further than al-Madani. In fact, Satyam was a situation where the judge went down a line that had not been canvassed at all, finding that certain properties were held on a bare trust when no one had contended that they were. And then in the Court of Appeal, the Respondents' Counsel didn't even seek to uphold that as a finding. That's paragraph 32 of the Court of Appeal judgment. So what is said by the Court of Appeal in that case is all against the background of the point not even being argued in front of it. And it doesn't in any event add materially to al-Madani. The Sainsbury's and MasterCard case also doesn't take matters any further. There the point arose in a rather different way, the question being whether the Court of Appeal should have dismissed the defence in question, having found that the first instance judge got it wrong, or, as the Court of Appeal actually did, send it off to the cat for another go. And the Supreme Court said, well, the Court of Appeal having reached the view that it did, then it should have grasped the nettle and dismissed the defence.
You're intruding on private grief.
My Lord, I know.
Tribunal.
My Lord,
multiple members of the tribunal.
I did want to take this with a light touch.
Moving swiftly on.
Precisely. But a very different case. And the Supreme Court in that case referred to the adversarial system and so on, and the judge has to adjudicate on the issues, and that there's no other higher interest in play that should cause the court to ascertain what it referred to as some independent or ultimate truth. But none of that is really in play here. Mrs. Justice Cockrill in our case didn't fall foul of it. The issue of equitable allowance was obviously in play, and she was right to adjudicate on it. She wasn't going on a search for what the Supreme Court referred to as some independent truth. And in other examples, it is clear that the judge is entitled to come to a view that is somewhere between two extremes of the parties' cases as presented at trial. I've already referred, for example, to the decision of Mr. Justice Voss in Akidia, where, as far as we can tell, he reached a view which hadn't positively been pursued by either party and hadn't even been the subject of cross-examination. Other examples we've given in our skeleton argument. One is Sibir and Slocum in Authorities Bundle 2, tab 22, where the Court of Appeal at paragraph 70 confirmed exactly this point in a case where the judge had made a finding about the date when parties had reached a particular subjective understanding, a date which neither side had advanced at trial, and the Court of Appeal said that he was entitled to have done that. We've given the references in paragraph 19 of our skeleton, and at paragraph 18 of our skeleton we also refer to the Court of Appeal decision Ali and Dink, where the court went through al-Madani, Sainsbury's and Satyam and concluded it wasn't a problem that the judge there had come to a particular intermediate combination of various factual assertions, where the combination was not one that either party had expressly pleaded. And the court there noted that al-Madani and Satyam were cases of the judge finding facts which were outside the ambit of either party's pleaded case. And that's not, we're not in the realm of that here. That's not what Mrs. Justice Cockrill was doing here. The court in Ali and Dink emphasised that an overriding consideration was whether it was just to have decided the matter in the way it was, and whether the losing party had not been caused prejudice. And I'll return to that shortly when I deal with what Mr. Weisselberg said about it. But we say here that there obviously was no such prejudice. My next subheading is to look at how the case was put by the defendants at the Phase 2 trial. And this probably does require turning up, at least briefly. The cases were pleaded, as the court knows, in what were referred to as the position statements. And the defendant's position statement is in Core Bundle File 2 behind tab 15. And the first place to look at is paragraph 18 at page 309 of the bundle, paragraphs 18 and 19. And I know Mr. Weissenberg showed you this yesterday. And can I just say as a precursor that one has to keep in mind certain different points or issues when looking at this, or sub-issues. And some of them we say got slightly, or in danger at least, of being mixed up in my learner friend's submission. And it seems to me there are 3 points to keep an eye on. The first one in the pleading is the reason the allowance is claimed. For example, time and effort, or skill and effort. And here, the phrase, and I'll come back to the phrase here, is the exceptional deployment of time, effort and skill, and so on, the reference to risk. The second aspect is the basis on which the allowance should be awarded. Here, pleaded a share of the profits based on the type of business in which the parties were engaged and the specific context of this case. And then the court may have seen there's an express alternative over the page in relation to a sum representing fees, drawings, and so on. The third aspect is the amount of the allowance, and here what's pleaded at paragraph 19 is at least 50%. And then there are further alternatives at the end of both paragraphs 18 and 19 for such basis and in such sum as the court thinks fit. And as I detected it, the claimant's complaint relates to at least an extent to each of those aspects. And I've broken them down into 3, but of course to an extent they overlap as well. And so looking at how this document deals with each of those, on the first of those aspects, paragraph 18 describes the deployment of time, skill and effort as exceptional. And that was, of course, the defendant's case at its highest. But that is not to say that it was limited in that way. It was, of course, a descriptive word explaining the highest point of the case. And the defendants did want to seek to establish that because, of course, being a discretionary aspect, the higher you can show you are skilled and the more effort you put in, you'd be able to say that weighs more heavily potentially in the judicial discretion. But there's nothing in those circumstances for a judge to be confined to finding exceptional skill or nothing. If it was, it would lead to a slightly ridiculous situation of pleadings where you had to plead a whole series of adjectives in the alternative, and we say that would be inappropriate, but also highly unusual. So we say the wording of this paragraph is apt to cover the defendant's deployment of time, effort and skill, whatever the court finds that to be, although the defendant's primary case was that it was exceptional. And I'll show you in a minute how it was pleaded elsewhere on that first aspect. On the second point, paragraph 18 also clearly pleads that the allowance should be calculated as a share of the profits, and the rationale for that identified here was that this was the context of what was referred to as the private equity business generally, but also in the specific context of this case. Now, I don't say we need to get too tied up on the description of this as private equity business, as some sort of term of art. That is how the defendant saw it in broad terms. But what one gets out of it for these purposes is that it's a reference to the type of remuneration that parties in this position, in this sort of business, whatever label one chooses to apply to it, would expect to receive. There is also, as I noted, a reference to the specific context of this case, and that can only be a reference to the 50-50 arrangement. The court may well see that that had been the topic of the previous section of the pleading over pages 308 and 309 in the bundle, and that fits with the 50% share of the profits that comes in the next paragraph. That is the context of this case. That is the pleading about how they were going to be remunerated. So we say, putting that together, that is a sufficient reference to the allowance being calculated by reference to usual or reasonable remuneration for parties such as these in this sort of work. And the fact that the precise words reasonable remuneration are not used is nothing to the point. On the third aspect, paragraph 19 then identified the case that it should be at least 50%, alternatively such sum calculated on such basis as the court thinks fit. And the 50% there is clearly a reference to the profit share as the basis. The at least, of course, covers the fact that the very primary case, if I can put it like that was pleaded was a profit share plus fees. The end of 18 at the top of the page, it's profit share and or a sum representing fees and so on. So at least in this pleading, it wasn't quite put that high when we got to trial. It was 50% plus other fees. So that's the at least. But that, again, we say doesn't prevent a finding of below 50% if the court thought that was fit, and indeed that's covered by the express words of the pleading in any event. So if we are into some sort of technical pleading game, we say the pleading is wide enough to encompass certainly what the judge found in this case. Paragraph 19a went on to deal with a particular point about the increase in value of assets and how that ought to be particularly reflected in the equitable allowance. And in the event, that was not the subject of specific evidence at trial, nor indeed did most of the deed of termination assets generally increase in value over the relevant period in any event, largely due to market conditions. So we don't need to trouble with that, and I don't rely on that for this purpose. And nor do we rely on paragraph 19b, which effectively related to responsive investments, which fell outside of the account in any event. Paragraph 18, as might have been picked up, cross-referred to section B of this pleading, starting at page 312, which contained a long section setting out in more detail various of the facts relating to the recovery services as they had been performed. I don't intend to run through all of that. There are a number of references within it to time, effort and skills having been performed. For example, on page 313, at paragraph 24 in the middle of the main paragraph, there's reference to the defendants having devoted all of their time, effort and energy to it. Further down at 24.2, there's reference to them dedicating themselves to what was required and utilising their considerable skills in the process. I'm not placing particular weight on that adjective, but just showing that it's all part of the description of what the defendants did. Over the page at 314, at the top of that page, reference to considerable workload having increased as a result of actions taken by Mr. Jaffe and so on, which increased risk, cost and duration of the work. Paragraph 31, which is a little bit further on page 327, then gives further details of the skill and effort. And on this occasion, it's referred to as experience and skills which made them individually and collectively uniquely well suited. But again, we say, although that was a description of the case at its highest, there's nothing that excludes, if you like, a case on non-unique skill. There are various attributes then pleaded for each of the defendants. There's a summary on page 328 under subparagraph 4. Paragraph 32 on page 329 summarised the hard work undertaken, entirely dedicated long and unpredictable hours and so on. And then to finish off, just to show you the last reference, I think, in this pleading, right at the end, there was a summary of the case starting at page 382 of this bundle, headed Conclusions and Summary of the Defendant's Position, in which various stages of the application of the various points of principle as the defendant saw them were set out. And one reaches on page 384 at subparagraph 5, the equitable allowance, that the defendants were entitled to an allowance in light of the time, skill, effort and risk which they expended in performing the recovery services. So certainly there, it's clear that it's not confined to a particular standard of skill or level of skill or effort or so on. I will just show you briefly the relevant parts of the written submissions at trial. They were referred to in my learned friend's skeleton, although he didn't go to them orally yesterday, but just to complete the picture. The written opening is found, or the parts of the written opening, in Supplemental Bundle 2, behind tab 27. The document starts at page 354, and the first relevant section, very briefly, is on page 367, where the defendants set out their submissions on the law as to equitable allowance, effectively referring to where an allowance should be awarded for the time, effort and skill in making the profits. I should pick up on page 369, there was a section about the 50-50 agreement, and this was dealing with the 50-50 agreement primarily as an issue of scope. One sees that in paragraph 62 on page 370, but at the foot of page 370, footnote 63, made it clear that there was an alternative case that if it didn't come in at the scope stage, the defendant said it provided the most accurate measure for their equitable allowance. So it was clear that that was being relied upon in that way. Page then 383, paragraph 220 onwards, then deals with the case in summarising it in a similar way to the position statement.
I'm so sorry, which page?
Sorry, page 383.
Thank you.
My lord. There's probably not much to pick up. It's quite similar to the position statement. Foot of page 383, footnote 418, makes the point that if the claimants had wanted to pursue the profits themselves, they would have needed to engage individuals similar to the defendants in order to do so and to reward them accordingly. And that is similar to a point one finds in the judgment at the end of the day as well. The written closing submissions are found behind tab 33 of the same bundle. The document starts here at page 488. The section that I wanted to show the court starts at page 522 with the subheading Equitable Allowance. And just very briefly, the case law was set out, various aspects of the factual case were then set out, including details on how much work. There was a section on page 528 on the quality of the work. And I just wanted to pick up on page 531 at paragraph 581, the submission that was made at that stage, noting that there had been a focus on the uniqueness of the skills, but making it clear that the defendant didn't need to prove it was unique to have an entitlement. That wasn't a condition of the allowance as explained in the case law. It was making it clear the case wasn't confined to unique skill in the way perhaps suggested. And then at paragraph 535, which is right at the end of the document, page 535, paragraph 589, dealing with the quantum of the allowance, started by saying the courts have paid particular attention to what, even if not binding, the principal and fiduciary agreed or would have agreed as appropriate remuneration. Paragraph 590 then submitted or invited the court to award the 50-50 profit share as the appropriate metric for quantifying the allowance, or indeed other equitable allowances the court thinks fit. So, bearing those documents in mind and going back to the three aspects of the equitable allowance case that I referred to, in relation to the first aspect, what justified the allowance, the case clearly was not confined to unique skill or exceptional skill or any such similar adjectival reference. Those were references that were made in different parts of the case. Other references were made elsewhere, such as considerable skills, or indeed with no adjective at all. But what was clear is that there was a case on, if I can put it like this, non-unique skill. And one only has to look at the summary paragraph at the end of the position statement to see that. What was important is that the skill and effort was put in play, and that the issue was to what extent had the defendants exercised skill and effort. Now, effort ended up being a non-issue because the claimants conceded it as part of the opening submissions. But in relation to both of them, and particularly skill, where the emphasis is now placed, it is effectively a range. Exceptional skill may be at its highest, but the range issue, if I can put it like that, what level of skill was before the court. And the pleading cases, that's why they don't help at all, because they're concerned with a factual hypothesis or a different factual hypothesis, not, if you like, a range type case. That's much more like Ali and Dink or the Sibir case, where the question is, what does the court have to find in order to get to the legal conclusion? On the second aspect, the level, the percentage, if I can put it like that might have been the third aspect before, but anyway, the judge awarded 25% when it was the 50% figure that was pleaded. In other words, just looking in an isolated way at the percentage, we just say that's not a valid complaint. 50% was pleaded as the primary case. There was a clearly pleaded alternative relating to another level if the court considered fit. But in any event, it cannot realistically be said that a pleading of a 50% allowance excludes a case of a lower percentage. That is never the approach to a pleading of this sort of case. We take, for example, a case in breach of contract for lost profit. The pleaded case might be we suffered loss of £1 million, but during the trial or in the judgment, the judge might find, well, actually on the evidence, expert evidence or factual evidence, whatever, you only suffered a loss of £600,000. The answer is not, you didn't specifically plead £600,000, you get nothing. It's you get the £600,000. So we say any pleading point based on the bare number is hopeless. And then the other aspect, the basis for the award, claimants have sometimes characterised it as market value, saying it wasn't pleaded or pursued. Well, first, as I addressed yesterday, I won't go back over that, the phrase market value wasn't actually used anywhere and is not particularly helpful as a term of art. It was about the value of the defendant's services and what was reasonable remuneration. And as I showed the court, including by reference to paragraph 18 of the position statement, that was always the point. The 50-50 arrangements were the best guide to that value. That was the defendant's case. And that's why the 50% was the primary case. But the basis for it was the value for their services and the remuneration for them. So that was in play. And on each of those aspects, the judge's ultimate finding was open to her on the pleadings and the submissions. And in any event, the pleaded case made it clear that there was a further alternative of, on such basis, at such level as the court may consider fit. And that would have covered it, even if the primary words did not. But I don't need to rely on those words anyway. And the judge noted in her judgment at paragraph 456 that the question she addressed, whether an allowance is justified for doing something with requisite, albeit not unique, skill that needed to be done, was within the pleaded issues. And she was right to do so. And I think I have explained why that was not outside the pleaded case. In terms of evidence, the claimants also complain that the judge's conclusion was not supported by any evidence. They say the defendants didn't adduce any evidence in relation to the amount of the equitable allowance. But that is wrong. The defendants did adduce such evidence, at least in the form of the arrangements they had made with Mr. Jaffe for their remuneration. And importantly, that was not hypothetical speculation as to what might have been negotiated. It was real-world evidence as to what was negotiated with and indeed agreed to by Mr. Jaffe, whether or not that amounted to a binding contract. And it doesn't need to be part of my case that it was a binding contract. The judge didn't find it was, and I'm just supporting her reasons. And Mr. Weisselberg accepted yesterday that those 50-50 or profit share arrangements did not need to be excluded entirely from consideration, which we say should be read as saying, well, I accept that it's fair for them to be included in consideration, and we say that is fatal to the submission that there was no evidence. Now, it's right to say that the defendants did introduce expert evidence as to market value, but there was no need or reason for them to do so. We addressed that in our skeleton at paragraph 36, and I covered it yesterday. In short, there's no requirement to put expert evidence in on such a point, and it's far from obvious that there would have been proper expert evidence to put in anyway, given the relatively unusual nature of this arrangement. And there was, in any event, factual evidence in support of it. There was, incidentally, other material as to what another potential provider had proposed to charge to the family. We referred to that in our appeal skeleton in footnote 10 on page 117 with the references there. But I don't need to rely on that. The judge didn't rely on it, and I'm not going to respondent's notice about it. But as a matter of fact, the defendants did advance such material. But the best...
You also say that insofar as it's possible to put in evidence of market value, that cuts both ways.
Quite so, my lord. It being on the pleadings that we were talking about remuneration, if the defendants had wanted, if the claimants had wanted to challenge what we said and said it's not reasonable, it was an outrageous sum, and so the court shouldn't agree with it, it would have been open to them to apply to do so and to do so. But they didn't do that. The best evidence of value in this case, particularly in the unusual circumstances of this case, was the arrangements the parties had made between themselves. And that was before the court. And I'll come back in a very short while to the 5 particular indicators that the judge relied upon. Next, I want to deal relatively briefly with the claimant's suggestions of prejudice or unfairness that they say arose from the way the judge decided it. They say they weren't given a chance to deal with the points. But the short point is that there was nothing that the claimants didn't have a chance to respond to. They chose not to deal with these points. The proposition that operatives in this sort of area and the people in this particular case are paid by carried interest or profit share was clearly pleaded in the position statement. And indeed, it's probably incontrovertible. There's never been any suggestion otherwise from the claimants. But certainly as far as the individuals in this case are concerned, there was never any serious dispute that Mr. Jaffe was willing to give them a profit share. The precise percentage may not have been finally nailed down in a written and binding formal document. But as the judge held, Mr. Rudhadze was always going to get between 40 and 50%, Mr. Alexeyev about 10%, and so on. There was also, for what it's worth, the evidence of other operatives within SCPI having a profit share. So that is the basis for remuneration in this area. Could never seriously have been controverted in any event. The defendant's pleaded case was that they were seeking a profit share by way of equitable allowance, and it was clear they were doing so by reference to the 50-50 agreement. It was said it was the most accurate measure for the equitable allowance. And if the claimants had wanted to argue, as they now appear to be saying they might have argued, that that profit share was for some reason either an outlier in the market or attributable to the wrong period of time or otherwise inappropriate as any sort of evidence or otherwise unreliable as evidence, it was open to them to do so, either by factual evidence, if they'd had any, of comparables perhaps, or expert evidence, if there was a relevant market. But
the difficulty with all this is that, as I read it, the judge didn't, in fact, in the end, regard the profit share agreement as relevant to the assessment of value.
Well, I'll come to the 5 points, but her I think, points B and C were the historic arrangements that had been made with Mr. Rudhadze and Mr. Alexeyev, that they were being remunerated. So true, she doesn't refer to it as, in terms of either the hypothetical, what would have been agreed had there been no breach, but she does refer to those as the arrangements that had been agreed in the past, and I will go to those points. Well, I'm slightly using the phrase profit share agreement in an inexact way. I accept that, but what the judge properly relied upon in her paragraph was the fact that they had always had an arrangement, well, Mr. Rudhadze in particular and Mr. Alexiev, that they'd be remunerated A, by profit share, and B, at this sort of level. Mr. Rudhadze, I think she says 40 to 50%, Mr. Alexiev 10%. And we will come to look at that, my lord. I'll just finish off prejudice first, and then turn back to that if I may. In terms of other evidence that the claimants say, well, they might have wanted to deploy, or other things they might have wanted to do, and we do ask rhetorically what other evidence sensibly could have been advanced about remuneration, given the unique circumstances of this case. Certainly not an obvious case for a market expert of sort of the going rate. But in any event, they could have put that evidence in if they'd wanted to do so on the pleaded case and on the case advanced. They could have cross-examined the defendants if they'd wanted to on the value of their services. They chose to cross-examine them at length about the equitable allowance on other points, but not about this particular point. And as the court seen, the defendants also had an alternative case that if it wasn't in profit share, they should get an allowance in the sum of fees, drawings, and so on. I mean, there wasn't any cross-examination about whether that would have been reasonable or not, or submission about that. There could have been. Or they could have even run a case saying, well, no, that is representative, and you should award that rather than the profit share. But they didn't make that case either. So it's not really open to them now to say, we could have run all sorts of other cases. Well, they could have done, but they could have done at the trial, and they chose not to. The reality is that the court had the key evidence, which is the arrangements that have been reached by the parties in this case. And so we say there's no possible prejudice in the judge having determined the case in the way she did. In other words, relying on non-unique skill. The case of what skill had been exercised was clearly before the court, and there was an awful lot of cross-examination about it, or indeed on the basis of the allowance, as I've already explained. And the claimants also say that if the claimants had, what they say, run the claimants, if the defendants had run the case as the judge answered it, if I can put it like that, they say there would have been a greater focus on the status of the recovery services as at May 2011. But, my lords and my lady, there was a great focus on the status of the recovery services at that date, at the trial. And that was because it was a key component of the defendant's case that post-breakup, the recovery services were so transformed that profits obtained from the latter period were not properly referable to the pre-breakup opportunity. That case was reflected at length in the defendant's evidence and was the subject of quite a lot of the cross-examination and of the submissions. And the judge rejected that case, saying it was a continuation of the work that had started pre-breach, but not, of course, as I showed you in the judgment, saying that the work was all over. But there was a focus on that point. And Mr. Jaffe gave evidence on the point himself, saying, which the defendants denied and the courts rejected, but his case and his evidence was that the bulk of the work was complete by May 2011 and could have been done from then on by the lawyers. We've given the references in our skeleton at footnote 11 on page 118. But principally, one can see that at paragraphs 402, 457 and 459 of the judgment. And to break it down a little further, Mr. Jaffe gave evidence about this being cross-examined, and he was essentially saying there was nothing difficult left to do by May 2011. It could have been done by the family paying someone $1 to $2 million per year. We've got that extract of transcript for the court if you want to see it in the Supplemental Bundle Volume 2, tab 30, pages 422 to 423. It's on day 3 of the trial. So he actually put that evidential case forward that they could have done it for $1 to $2 million per year. And that was part of the evidence, by which I mean his whole part of this evidence, that it was basically all over, the hard work was already done. That was rejected when the judge said it was just not a case of defendants being able to pick up the fallen fruit after May 2011. There was substantial work still to do. So this area was heavily traversed, and the idea that there would or could have been more evidence about the status of the recovery services at May 2011, we say is entirely unrealistic. So we say there's no prejudice or unfairness to the claimants at all. They had the opportunity to say what they wanted to say about it. They didn't. But that's no doubt because everything that could be said about this was said at the trial. And related to this point, under my next subheading, is the point the claimants take about timing, if I can put it like that. They say that when assessing the defendant's work based upon the profit share that they had agreed, they say the relevant point for assessing the value of the defendant's work, the relevant point in time, was at the time of the breach, not, they say, the time earlier in the story where they negotiated their profit share with Mr. Jaffe. This was sort of the 2008 versus 2011 point that Mr. Weissenberg made yesterday. And they say that that means that the profit share arrangements were not a reliable data point as to value. They seem to be saying that because much of the work had already been done before the time of breach, the value that the defendants could command in 2011 would have been less than previously. And we say that's misconceived for 3 reasons. First, this part of the argument from the claimants proceeds on the basis not that there was no evidence, but that the judge gave this particular piece of evidence the wrong weight. And we say that is a matter for the trial judge in her discretion. And I gave the reference to the Ming Siu Hong case at paragraph 28, Roman 3, yesterday. Second, the premise that the work had basically all been done by 2011 is a false one. We've addressed it at paragraph 39 of our appeal skeleton. I ran through quite a lot of this when we looked at the judgment yesterday in terms of the work and when it was done, and indeed the judge's findings about that. But also the claimant's point has an air of unreality about it, given that the defendants did not even enter into an overall agreement with the family, providing the defendants with their overall remuneration, the IRSA, until September 2012. And by that point, the family were not contractually committed to the defendants. They had avoided being contractually committed up to that point. And so the fact that they were still prepared to engage the defendants in September 2012 on terms that potentially gave the defendants a large carried interest demonstrates that the defendants remained essential to the work that the family needed doing. And in fact, the recovery services continued on for another 5.5 years after that, until April 2018, when the deed of termination was signed. The judge also referred at paragraph 54 to the family's need for continuing recovery services following May 2011 as pressing, and she said it was critical that the recovery services continue. If it really had been sort of all over bar the shouting at that stage, that sort of language just would not have been used. And as I say, I've already referred to the other parts of the judgment where the judge confirms that there still remained hard work to do and that the defendants needed to do it. But third, in any event, the periods of time cannot be parcelled up and separated in this way. The work done in support of the remuneration that was eventually gained by the defendants under the deed of termination, that was done before and after the breach. The profits that were earned and that the defendants have had to account for in this litigation were calculated by reference to all of the recoveries made by the family. They didn't start the clock at May 2011. There wasn't a parcelling up of the profits for the account, and so one cannot parcel up the work that had to be done to earn those profits for the allowance. And as I've said, the judge rejected the argument that the recovery services had fundamentally changed post-breach. And part of the reason why the defendants were found to be in breach in the first place was that they had resigned in bad faith to pursue a maturing business opportunity that had, prior to breach, been pursued by the claimants. So they had to account for all the profits derived from their work with the family. There wasn't a sort of apportionment to say, well, let's just see what derives from work done post-May 2011. The profits were calculated by reference to all of the family's recoveries. So the 50-50 agreement, the arrangements, were a perfectly good marker for what the defendant services were worth. In other words, the services that ultimately generated the profits that they have had to account for. And then lastly, I just wanted to turn to the 5 particular matters relied upon by the judge in coming to her 25%. The claimants, of course, criticised the judge for relying on these points, saying that her reliance was wrong and illogical. But we say it was nothing of the sort. And there are 3 general points, very shortly. First, all of these factors were based on evidence in this case, illustrating that the judge did ground her decision in the evidence. Second, the factors were not irrelevant. They related to the price payable for the performance of the services in this case. And third, the weight that the judge was willing to attribute to them was, as a matter of her discretion, a matter for her. We've dealt with each of the factors in our skeleton at paragraph 44, but it's probably easiest to look at them as listed in the judgment, which, as the court knows, is Core Bundle 1 tab 9, and the relevant paragraph is 469, which is at page 214. It starts towards the end of page 214 and goes over onto 215.
Just before we deal with those, tell me if this is an inconvenient moment to address it, but I'd like a little bit more help on paragraph 465, and by reference to the point that my Lord Justice Phillips was making, and the rejection at that stage of reliance on what she has in fact made a finding about as to what would have happened. And she says in the last sentence, the case is caution against analysing by reference to what would have happened had there been no breach. See, for example, and then there's a reference to Murad at 76, which cites a passage in Regal saying normally it'll be difficult to work out what the counterfactual is. And then there's a reference to what I think is a different passage in Regal, which is a passage which just involves the general proposition that you have to account for profit. It's not dealing with extra allowance at all. And then there's a reference to Boardman, and I'm afraid I couldn't find what that page reference was a reference to. And the reason I just want to explore it a little is that, that your submissions tended to suggest that one of the reasons the judge, quite apart from the 5 particular reasons, one of the reasons the judge was entitled to take 50% as the value of the services was her finding that that's what would have happened on the evidence. And although at 465 she seems to be rejecting that as something which isn't open to her, if she's wrong about that, I don't know whether you're saying, well, actually she was entitled to do it, and that is a further reason for upholding her judgment. The error of law in that respect was one which favoured the claimants.
Well, as I read paragraph 465, she records the fact that our case was base it on the profit share agreement. She says 40%, we say 50%. Leave that aside for a minute. She says it's the wrong approach. She says there's no valid profit share agreement, and the case is cautioning it's analysing by reference to what would have happened.
Well, Paul, yeah, sorry to interrupt. The first half can fairly be read as meaning you don't automatically get whatever the profit share agreement was, if there was one. But the last sentence does have her seeming to treat herself as bound as a matter of law, not to take any account of the counterfactual. Doesn't it?
Lord, I'm not sure it goes that far. She certainly rejects in the previous sentence reliance upon what the defendant had been calling a legally enforceable profit share agreement because she had found it wasn't legally enforceable. So in other words, that as an existing agreement, she puts that to one side. She says the case is cautioned against analysing by reference to what would have happened if there had been no breach. And of course, there's quite a lot of authority saying you don't engage in hypothetical analysis in this sort of area when it comes to working out, if you like, the basic scope of the account. But I'm not sure there she is saying, and therefore I'm going to put it out of my mind entirely. I think what she's saying there is that that is not, if you like, in and of itself, an automatic point that leads me straight to whether it's 40 or 50%. So
that might have been sustainable if then she had made some reference to it in 469, but it's evidently excluded from the factors that she considered pointed her to her conclusion. So I think reading 465 and 469 together, it certainly seems as though she has left out of account the counterfactual that there would have been a profit share agreement.
Yeah, Lord, I accept that when she comes to 469, the indicators that she sets out there do not include the hypothetical agreement that elsewhere she said would likely have been reached had the parties gone ahead. I accept that. I think what I'm saying is at 465, she hasn't entirely ruled that out as a possible factor. I'm not saying by that you should then read it into later, but I'm saying she could have continued to keep that in the mix as well as a further supporting point to the 5 indicators she finds under 469. I think what she's doing at 465 is saying you can't proceed directly, as it were, from a finding on the hypothetical to the equitable allowance.
I don't think she is saying that, is she? She's saying that you had advocated a 40% allowance based essentially on the profit sharing agreement, not directly. And that's the wrong approach. And then she explains why.
Yes.
It's because cases caution against analysing by reference to, not directly from, but even by reference to.
Well, yes. I mean,
what would have happened?
Yes, maybe.
Seems to me fairly clearly she's saying this just isn't territory upon which I should embark at all, and I'm not going to.
Well, that may be what she's saying. It may be that I'm reading that last sentence slightly more softly than my Lord Justice Phillips is, where she says caution against. And it seems to me she's saying...
Well, it rises from... You have to read that as the explanation of the fairly strong words, the wrong approach.
Yes, no, I entirely accept that what she's saying overall in that paragraph is you can't proceed from what has been referred to as the profit share agreement directly to, and thus the equitable allowance.
She's not saying directly, is she? She's making it fairly plain that she's not saying directly. She's saying by reference to.
Well, she is saying that, but it seems to me that she's giving 2 reasons. One, because there's no valid profit share binding agreement, and 2, I can't engage in the hypothetical, or at least the cases caution me against doing that. Now, as it happens, I suspect we're starting to argue about something that we don't need to argue about, because it's not any part of... I'm not trying to read into the factors in paragraph 469 the hypothetical agreement. I haven't got a respondent's notice. My case is supporting what she said in 469. I was slightly taken down the road by Lord Justice Popplewell, perfectly fairly, and the extent of my point, based in response to his comment, was that on my reading of 465, she could have kept in the mix as one of the factors going to her discretion the hypothetical, if you put, and that wouldn't infringe the principles in Murad and Regal and Boardman, which are all really dealing with how do you define the scope of the account in the first place. But I haven't got a response notice saying we support it on that ground as well. I'm quite happy to take my stand on the points as they appear in 469. Right. For what it's worth, Lord, the answer to your question, I can't find the reference to Boardman at 154 F to G. We think that should actually be a reference to Regal Hastings, a second reference to Regal Hastings, because that is actually a passage.
That may be the passage that's quoted in Murad.
It may be. It's a passage that's got a red line by it in our authorities bundle as well.
Yes, so that is, both of those are, we shouldn't go down that route because it's difficult.
Yes.
It's a difficult exercise.
Yeah. It's counselling against the use of the hypothetical in cases of account of profits of breach of fiduciary duty for those reasons, and Murad is strong on that as well. And that arises in those cases when they are setting the scope of the account, and where people have tried to run arguments to say, well, such and such shouldn't be in the account because, absent a breach, something else would have happened, and the courts have said you can't do that.
But not appropriate, where, as you say, is this case, the counterfactual actually gives you the evidence as to what fair remuneration for the services is.
Precisely, my lord. It seems to me that would be a perfectly reasonable point to take into account in the exercise of a discretion if the judge thought it appropriate. In this case, she didn't need to, and the points she relied upon included those under 469. They included B and C.
Can you first of all explain A to me?
Yes.
I'm afraid I just don't really understand the relevance of A.
Well, I think this is actually a response anticipating a point that my Lord Justice Phillips made yesterday. And I think, as I understood it, the point yesterday to Mr. Weisselberg was, he said, well, under the pre-existing arrangements, the defendants were going to get 50%. And in the post-2011 world, they were doing all the work. So, in a sense, you could say the 50% rather undervalues their services. And I think this is an answer to that, to say, no, the worlds pre- and post-2011 are comparable, because in both scenarios, the defendants were going to be doing, which is the lion's share, but the frank position is all of the work. So it is relevant in explaining why the profit shares before 2011 are as appropriate a reward for the defendants done after leaving Revoker as they were for the work done before, to show it's a comparison of like with like. In other words, explaining why the judge wasn't taking 50% and going upwards.
So that, you say, implicitly is an adoption of the 50-50 agreement as a measure.
Well, Lord, I think it might well be, because she is there implicitly referring to the fact that after 2011 they would be doing that work. But in any event, I think it helps set the scene for the historic position as well that she comes on to in B and C. And she refers to Mr. Rudhadze having previously been remunerated based on a percentage. She says 40 to 50%. And Mr. Alexeyev, whilst originally employed on salary, expected a percentage participation of some sort in the range of 10%. Just for the court's note, her reference back to her Phase 1 judgment at paragraph 335 is to a document she referred to in her Phase 1 judgment which sets out Mr. Alexeyev's 10% share of the profits, which she had found at paragraph 334 of her Phase 1 judgment was contractually binding. So where she says expected a percentage participation, paragraphs 334, 335 of her Phase 1 judgment actually explain that that was a contractually binding entitlement. Now, the claimants say that those points are irrelevant because they represent what the individuals expected to receive if they'd stayed loyal, and because they represent profit shares expected by those who had already been working on the recovery services for the previous period. I think there's 2 points in there. The second of those points I've really already dealt with. We say that the point about splitting up the periods is not a good one. It's an artificial split because it doesn't compare like with like in terms of work and services provided and remuneration, and because on the facts they're wrong to say that by 2011 there remained little to do. And the second of those points, or the other of those points, the fact that matters did not go forward because they breached their duties doesn't affect the relevance of the historic arrangements as to the determination of what a reasonable allowance was. In response to the claimant's appeal, we're not seeking to enforce an existing or any formal and binding profit share agreement. The point is that the price that Mr. Jaffe was willing to pay for their services is the best available evidence of the value of the work.
And actually did.
And actually did pay, my lady, yes. And that is, we say, the most suitable marker as a guide to what the services provided were worth. And it is similar to how the courts approached matters in cases such as Fishel and Kingsley that I referred to yesterday. In those cases, the pre-existing arrangements were used as a basis for calculating the allowance, even though they had either come to an end or did not apply to the profits in question because they'd been obtained in breach of duty. So it is not a question of the judge in these paragraphs, and this is how the claimants put it at one point in their skeleton. It's not a question of her conducting a hypothetical negotiation with a third party. As I say, that might have been one way of looking at it, but it's certainly not the only way, and the judge wasn't mandated to look at it that way. What she was using was the arrangements that the parties had made as a guide to what a reasonable allowance would be in all the circumstances, and that was a perfectly appropriate thing to do.
I can see B is what was actually paid by way of remuneration, but don't C and D also fall foul of the judge's cautionary note? Those are matters which were what would have happened.
Well, my lord, no. As I mentioned, C, although she says they expected a percentage participation, as I gave the references to her Phase 1 judgment, where she actually finds that the document in which that is contained is a contractually binding document. So that's an agreement that has actually been reached. So you've got historic arrangements. Actually, even if it wasn't binding, it wouldn't matter for this purpose. It's an obvious, even if it's just an obvious understanding, it is an evidence as to how the parties in these circumstances valued their services. So it's not there stretching into the hypothetical, even if it was only an expectation. It was a historic, real expectation. That's different from a what would have happened in a hypothetical world analysis.
It's an expectation based upon an agreement,
At the
whether
time,
or not
yes.
a contractually binding agreement, although you say it was.
My Lord, yes, it's a historic fact. And the point about Mr. Marson under D, the judge said he had been previously employed, he had been anticipating some share of the proceeds, and it said against me that's irrelevant because it refers to an expectation of the proceeds in return to his disloyalty. And we say that slightly misses the point, and you do have to look at these points altogether. Standing back, in terms of overall percentage, the split between the three defendants in terms of that doesn't really matter. The point is that it's the combined services of the defendants were recognised at that time as being worth about 50% of the profits. And that had always been the position. The fact that it was originally, or at an early stage, Mr. Rudhadze and Mr. Alexiev alone, and then subsequently included Mr. Marson, doesn't really change things. It's the collective provision which counts, because what she eventually reaches is a collective allowance for the three of them. The point the judge was making, that Mr. Marson was aspiring to a profit share, so there's no reason to exclude him. And indeed, I think we've made the point that was actually under discussion with Mr. Jaffe even before the breakup. And that's in the first phase, the first judgment, paragraph 247. And then in E, the judge also referred to arrangements that have been discussed at an earlier stage with Mr. Houff, something in the region of 50 million plus expenses, and he'd been told, don't do it for much less than 100 million pounds. And the claimants say this is irrelevant because they were discussed in very different circumstances. He never even agreed to them. And it's right that this dates from an earlier stage, around mid-2008. And I think it's right to say that this may not have been the primary point for the judge, and indeed it's not a point that I put a vast amount of weight on. But it doesn't mean that it's an entirely irrelevant point either. In terms of timing, one can't just parcel up the periods of time in the way the claimants seek to do. I've already been over that. What this does do is at least give a cross-check, if I can put it like that, against what the judge is thinking in relation to remuneration. Mr. Houff was someone else, unconnected with the defendants, in fact, at the time in competition with the defendants to provide services.
Well, indeed, in competition with SC.
Sorry, in competition with SCPI. And he was seeking to perform the services for the family. So again, you've got quite a good comparator, if only showing that the judge was in the right ballpark. And in a sense, I don't need to put it any higher than that. It's a cross-check or reality check, or however you want to put it. It's not entirely irrelevant, though. And it supports her finding that the value of the defendant's services must be considered to run into the tens of millions. And certainly the Mr. Houff material supports that. The key point, and I don't shy away from it in all this, though, is that the judge had the important metric of the historic arrangements between the parties, which were real-world arrangements and not hypotheticals, which certainly amounted to 40%, if not 50% collectively. And then the others are supporting points. And we say that in looking at those points, they were entirely fair points for her to rely upon. None of them are irrelevant. And she was right to look at them and right to use those as a basis for finding what an appropriate equitable allowance was. She took them into account. She took into account the circumstances generally pertaining in the case. She took into account what was said, for example, in O'Sullivan, that should be aiming to approximate to the value, but not to take full account of the contribution or to award them at all as much. And she found that 25% was appropriate. And we say that's not only consistent with what she sets out there from O'Sullivan, it's also consistent with the other cases that I showed or referred to yesterday, decisions such as Kingsley and Fishel and Akidia, in terms of using that sort of material to arrive at an appropriate equitable allowance. And we do say that was the best evidence to rely upon, which was the actual arrangements that had been made between these parties to provide these services. Now, it is of course clear that this was an approximation when she comes to 25%. It is clearly something of a broad brush, but it is none the worse for that. The authorities, as we've said in the skeleton, are replete with references to this not being an exercise in mathematical precision. And she inevitably had to take that sort of approach in working out what allowance to award, having rejected the, if you like, direct route of 50%. But we do say that was not only open to her, that was entirely consistent with all the authorities. And it comes to a conclusion which is, not only in her judgment, but which is obviously fair in the overall scheme of things. It takes account of all of the various relevant points, including the, whether you call it the deterrence point or the no incentive point, because they don't end up with as much as they would have done absent breach, because as we know, absent breach, she found they would have had 50%. So,
can we just go back to paragraph A and the possible relevance of that? I mean, one of the oddities about this case is that the pot that we're talking about is actually the money made from the family. The family have done a bargain. They've reached a bargain as to what they think, essentially, or you might say they've reached a bargain as to what they think the reasonable remuneration is. And that is also relevant. And that perhaps you could read paragraph A as saying, well, they've engaged this team to do that work for that amount. They are doing the lion's share. They would always do it.
well, Milady, yes, I think it is. And I think one can read that into A, because one knows that in 2012, the family still thought that these services were worth the deal that they struck with the defendants, which has ended up being the entirety of the receipts which the defendants have got from the family. So in that sense, if one's using that as a metric, albeit 12 months later, if you're trying to look at it chronologically, but nonetheless, it's still for the same pot of services over that same period of time. It's actually a much greater amount. And I'm not.
Well, by definition, it's 100%.
Well, yes, I'm about to say I'm not.
Why it helps you?
Well,
anyone.
Well, I'm not saying, and therefore that's the answer, 100% allowance. Of course, I'm not saying that. But if one is looking at the available evidence as to what people thought these services were worth during this period of time, it is relevant to bear in mind.
I'm just conscious the judge would have had well in mind that the family had done that.
Yes, the family were prepared to pay that much. And that really encapsulated in A that the defendants were doing all the work for that money, and now are seeking, or at trial were seeking half of it, and indeed in the appeal that Mr. Wolfson has opened, seeking half of it, not all of it. My lords and my lady, those were going to be the end of my submissions, unless there's any other points that I can assist with.
Not on my part, thank you. Lord Wolfson.
Have a break. My lord, would it assist the court to take a break now?
Yes, it would.
Court rise.
That's fine. Good.
see that you're looking at.
I know, I am.
England have passed the biggest sport ever except for the first day of the test match.
Yeah, over 500 runs in 4 centurions. Yeah.
What's the current score?
They're finished now.
What was it?
506 before.
Yeah.
And that's not even a full day. They went off a bad line.
Oh, did they?
That was 75 overs.
Wow. Gosh, another 15 overs.
Another 100
Another 8 or
runs.
something. Another 6. Oh, yeah. Yeah, you could have got close to 600 at that rate. It'd be like 580. Well, they scored something like 24 boundaries before lunch or something like that.
Even off the last over of the day, Stoke scored 18. 3 4s and a 6.
Yeah.
Well, a bit ICCC on my way in this morning. And they're saying, off the first 20 overs of England's innings, they'd score more runs. They'd scored more runs than we did in the T20 World Cup final.
Right. But all those things are around. Sunday afternoon, 40.
Court's rose.
My lords, my lady, I'm conscious that these are reply submissions. I propose to take the topics, if I may, in reverse order. So I'll start with delay and then say a word or two about the 50-50. On delay, I propose to respond directly to what my learned friend Mr. Weisselberg said in the submissions section of his delay chapter, splitting up the issues roughly as he did. So I hope it'll be easier for the court to look at the issues in parallel. First, my learned friend took 2 procedural points, which I can deal with very briefly, I hope. First, he said that the learned judge was correct to find the delay point was a matter for phase 1 only. Our short response to that is that it really assumes in my learned friend's favour precisely what we're arguing about. Phase 1 was about whether any equitable relief, including an account, were they so to elect, should be granted at all. So it necessarily wasn't appropriate for us to raise their arguments about how the account should be fashioned. And that obviously then goes back to the main point of principle on which I've addressed the court. The second and other procedural point I wanted to make was in relation to my learned friend's treatment in relation to Murdoch. We don't need to turn it up again. The court has now seen it on several occasions. But the court will, I'm sure, have picked up that when my learned friend took the court to Murdoch, he skipped over paragraph 197, which we obviously submit as a crucial part of the court's reasoning in that case, and we say sets out the 3 tools available to the court for fashioning, to pick up the word used, the account, i.e. Profit share, equitable allowance, and standing by. And that was obviously very much the forefront of our submission. So although, of course, the court has to look at the whole of that judgment, it was notable that my learned friend took the court to 195, 196, 198, but not 197. I've addressed you already on the pleading point in relation to delay. The court will have seen that we did plead the concept of unconscionable delay and what we said were the consequences thereof. That's at paragraph 20 of our position statement. As to the dates, listening carefully to what my learned friend said and looking at the transcript as well, my learned friend didn't, I think, dispute that we ran the points concerning the dates in our skeleton and closing submissions. His point, it seemed to me, was that that should have been in the pleading. The relevant point for practical purposes is that the whole of this period was traversed in considerable detail in the evidence before the judge to analyse whether Mr. Jaffe should have brought the proceedings at an earlier date, whether he could or should have been able to afford to do so at various points and so on. And that was the basis on which the learned judge reached the conclusions she did. So there's no, in my submission, there's no point of substance there. putting to one side the issue of unconscionability, which I'll come to next, the only other real issue in relation to whether there was what my learned friend called culpable delay. And he used that phrase a few times, and I'm happy to pick it up, although I do underline it's not a phrase, if I'm right, which we actually find in the test and the authorities. His real issue is whether and at what stage it was viable for the claimants to take requisite action. Now, as to the question of what we say the claimant should have done, my learned friend at one point in his oral submission said, although letters were not sufficient, his clients, he said, had done more than sending letters. But he then went on to set out what the content of the letters was. So it wasn't actually clear what he was saying his clients had done more than send letters. And we say on the basis of Clegg that merely sending letters are insufficient. You actually have to start legal action. I've already shown the court, I won't go back to it, the judge's conclusion that Mr. Jaffe could afford to commence some form of legal action. And it was when I was making that point that my Lord Justice Popplewell referred from his recollection to the case of Cecil and Byatt and asked us to consider whether that might be something which the court ought to look at. With respect, we have looked at it. We do think it is helpful. It's obviously different, but it's helpful to look at it by way of an analogy. We've brought, obviously, we've handed to my learned friend. I don't know whether they've reached the court. They're en route now. And I should just make clear for form's sake, because although, of course, I'm taking a new case in reply, it is in response to what was put to me by Lord Justice Popplewell. I do propose to take this relatively quickly because it is by way of analogy and it's in response to what Lord Justice Popplewell put to me. But just to put it in context, this was a decision on an appeal from an order granting an extension of time to serve a claim under CPR Rule 7.6 beyond the usual 4-month period. And the issue was, did the claimant have a good reason for delay in circumstances where the defendants were potentially being denied a limitation defence? And one of the reasons we relied on for the delay was that the claimants had waited until they had enough money to fund the entire litigation rather than enough money to get going, if I can put it that way. We see that at paragraphs 37 of the judgment in the judgment of Lord Justice Stanley Burnton and at paragraph 81 of the judgment in the judgment of Lord Justice Ricks. And with respect, it does come out, if I may say respectfully, a little bit clearer in the judgment of Lord Justice Ricks. I would invite the court, when the court's looking at this case, to have a look at paragraph 81, which sets out the issue. Essentially, the court concluded that there wasn't a good reason, and the relevant question was whether the claimant could afford to commence litigation, and that was especially the case, it was said, in the context of large-scale commercial litigation. That's a point which Lord Justice Ricks deals with between paragraphs 96 and 98. The first sentence of 98 puts it in memorable terms. This is commercial litigation on a grand scale. And Lord Justice Ricks goes on to consider the issue. And the quickest way, I think, to see his conclusion, which as we read the case, essentially all the judges agree on this point, is paragraph 107. And it's really the first few sentences of 107. If the claimants are only prepared to litigate if they had funding in place for the whole litigation, they ought to have served promptly and asked for a stay pending finalisation of the funding arrangements. So the first point is they should have got going and then asked for a stay. The second sentence underlines the importance of getting going, if I can put it that way, because the learned judge goes on to say, I'm not saying that such a stay ought necessarily to have been granted, but it would have been a much more reasonable request to have made. So that's Cecil and Byatt. I hope I'm being realistic. I'm putting it before the court as a comparison and in response to what my Lord Justice Popplewell said. But there is a resonance, we would say. There's a resonance for our case as to how the court analyses what Mr. Jaffe ought to have been doing. And that's particularly in light of the point which I submitted, that when we saw Mr. Jaffe telling Mr. Fomichov that he needed $500,000 to get the proceedings up and running, and then we saw how he was making a decision as to what was in his own interests best to do. That point probably brings me to the next point, which is the unconscionability point. And on this point, my learned friend, Mr. Weisselberg, says, well, we can't say that the delay was unconscionable when the judge found it was not. That was the point he's taken against me. As to that, as I've sought to show the court, we respectfully say that the learned judge was asking the wrong question. The fact that Mr. Jaffe, by his own lights, was taking a commercial decision in his own interests, and that commercial decision was a reasonable one if you're situated as Mr. Jaffe was, balancing various commercial interests, that doesn't answer the question whether vis-a-vis the defendants who are taking the risk, I'll come to the question of risk, who are taking all the risk, it's an unconscionable position to take. And indeed, as I submitted, it would almost invariably be the case that it's in your own interest to take a wait-and-see position if you can get all the upside and none of the downside. And so the correct decision, the correct question to ask is whether Mr. Jaffe stood back while the defendants took all the risk. Two questions arise on that, which I'll deal with in turn. First, what was the risk, and why was the judge wrong in her analysis of it? Second, is the existence of any such risk sufficient to establish unconscionability, or do you also need to show that things would have been different if the claimant had acted earlier or differently? That was the point that my Lord Justice Popplewell put to me in argument. Let me deal with those in turn. First of all, as to what the risk was. The main risk on which we rely is the commercial risk that we wouldn't reach the carry threshold. And on that point, I do submit with respect that my learned friend didn't really have an answer to the point put to him by my Lord Justice Phillips, that time is money. And in the real world, certainly time is money. Even in my world, time is money. But certainly for business people and entrepreneurs, time certainly is money. And for what it's worth, there was witness evidence in this case as to what the defendants would have been doing if they hadn't been carrying out the recovery services. And where my learned friend got to in the judgment, and the court will recall, we were looking at, on the one hand, paragraphs 117 and 18, and on the other, in particular, paragraph 454, was that my learned friend ended up slicing and dicing the judgment and submitting, well, 117, 118 is all theoretical, and 454 is on the facts. I think that's where he got to in his oral argument. We respectfully say that's wrong, and that when the court looks again at 117 and 118, and then the paragraphs at the end, in particular 454, we see 117 and 118 are concerned with the risks as to whether you will actually get the carry. And when one looks at the factors in the subparagraphs at 117, we respectfully submit it's clear from that. The judge is focused there on, will you get the carry? And that's where the judge found the carry threshold was no mean feat, that my clients were taking extreme and indeterminate risk. At the end of the judgment, the learned judge is looking at a different point, which is whether we're going to get the loans repaid. And she says, well, that's not a real risk because the family at some point is going to have money coming in. And so you're going to get the loans back. And of course, situated where the learned judge was, I mean, my clients obviously would have liked to win on both points, but situated where the learned judge was.
Sorry, are you saying those comments at the end are limited to loans?
In 4.5, when the learned judge is talking at 4.54.
Okay, but we're also looking at the 600s. You think 454 is just about loans?
That's the way certainly we read it. One has to, if I may put it this way, one has to assume that obviously when the London judge is writing 454, she's aware of what she said at 117 and 118. In 117 and 118, we are talking about the...
She's not just talking about the
Well,
loans.
in 453, she's talking there about personal risk and a question of whether the recovery service is necessarily involved undertaking a physically perilous mission. I mean, there was some evidence in the case, and of course my clients personally feel pretty strongly about it. There's some evidence of cars being blown up and all the rest of it. And the learned judge says, well, first of all, one point she said is, well, you were going to have to take on those sorts of personal risks even if you were working in the SCPI world. Well, true it is, but of course we say even in relation to that, those were risks which Mr. Jaffe was no longer taking. He wasn't at risk of having his car blown up. But that is the way we read it. And in 454, the point and the reason we do say that is if my lady looks at 454 and starts 1, 2, 3, 4, 5 lines down,
yes,
there was commitment.
There is a reference to loans.
Yes,
it's
and
not the only reference.
No, it isn't, but it's because it follows there was a degree of commercial risk in that the defendants for some time didn't know how well remunerated they would be. They did loan the family money at certain points, but that doesn't mean there was a real risk. They were effectively betting on a certainty. And the question is, what does that sentence go back to? We read that as going back to the loans. And of course, the main reason, of course, they're making the loans is to keep the train on the tracks so that in due course they will hopefully, although there's a risk, meet the carry threshold.
Yeah, I would suggest you need to read the paragraph as a whole.
Ultimately, the court has the judgment. The learned judge, I do respectfully submit, has to be understood as remembering what she says in very strong terms in 117 and 118 when we come to these paragraphs. I'm not sure there's very much more I can say that the court will have the paragraphs.
These paragraphs being 454 and 632.
And 632, yes, my lord.
I read 454. She's saying almost that the loans are an exception to what she said above.
Yes.
They did loan the family money at certain points.
An exception in the sense that, just so I understand my lord's point.
In other words, it's not what she's been talking about above. She's talking more generally above, and then she says they did loan the family money at certain points, but that does not mean.
There was yeah, I mean, if I think, as I understand my lord, that what she's saying is the loans, I'm not really putting much emphasis on the loans as regards risk. That's different to the hurdle. That's essentially my submission as to what the learned judge is doing here, because her language in 117 and 118 is clear and stark. We would respectfully submit.
But even if you're wrong about that, and in the light of 632, what she was saying when you take all the passages together is what I understood Mr. Weisselberg to be submitting, namely that there was a risk as to the carry interest, but no risk that there wouldn't be a very significant recovery one way or another. You say that actually what matters is risk in relation to the profits which you're being asked to disgorge, not risk in relation to some recovery.
But my lord, yes. And of course we have to remember, how should I put this point politely in this court? We have to remember that a lot of the money was going to come in ultimately by way of litigation. And there was huge litigation, as the court is aware, in relation to these monies which came in. And the one thing anybody practicing in this court or in the commercial court below knows is that there isn't any such thing as a surefire case. You may think you've got a very good case, but well, I'll limit it to myself. I've lost cases which I think I should have won. Maybe I've won one or two which I think I should have lost. But there is no such thing as a sure bet. So not only is there risk in the sense that will you get enough money in to get over the carry threshold, one also has to take account of the time that will take. It took 5-6 years. But also whether the money will come in. It's all very well to say that these families were billionaires, they had lots of assets. The people you're litigating against are also pretty wealthy. They're also able to put together very strong legal teams. And they are, one just has to look at the names. They're far from being pushovers. So there is considerable risk along the way. And then the point that my Lord Justice Popplewell put to me as well. Now, the other point my learned friend took in this context was whether Mr. Jaffe knew about the Ursa hurdle. Now, the first point in response to that, and it ties into the point I was just making, is that we're not saying that the Ursa hurdle risk is the only risk here. It's one of the risks, but it's certainly not the only risk. And of course, he knew that we were taking the wider and broad risks inherent in the recovery services, for example, the litigation risks. But in any event, we respectfully submit that it is not determinative in any event as to whether his behaviour was unconscionable. To put it at its lowest, Mr. Jaffe knew that the deal that he had proposed, which was a flat rate, i.e. no hurdle, had been rejected by the family. He was only willing to work on that deal, which is one of the reasons Revoker didn't get the contract. He was happy for us to sit down and watch us go out and work on what he logically must have known to be a less advantageous contract. And it's simply unrealistic, we submit in those circumstances, to say that, I think this was the word my learned friend used, that we chose to impose that hurdle on ourselves. Of course we didn't. We had to get the deal which was available from the family. We had to get the deal done in circumstances where he couldn't. So those are my submissions on what was the risk. Turning now to the detrimental reliance or causation point, as I think it became termed in argument. Our primary position is that that is not a necessary element in the doctrine of unconscionable delay. And as a matter of principle, and by contrast, for example, with concepts such as estoppel, or sometimes waiver, which requires reliance by the representee, unconscionable conduct, we submit, involves only an analysis of the claimant's conduct.
We're not concerned, are we, with unconscionable conduct? We're concerned with whether it's unconscionable that you should disgorge the profits in the light of the conduct. Isn't that what the unconscionability applies to?
Yes. Well, yes, I accept that. It's whether the claimant's waiting and seeing renders it unconscionable for the claimant to call us to disgorge profits, or to disgorge all of the profits.
Right. So one's not focusing just on the circumstances of the delay in terms of what it is or isn't unconscionable. One might say, well, you certainly have to have a degree of culpability before you're going to get into the right territory.
We submit that the way to analyse it is to say, if the claimant has stood by and let us take all the risk, that we do submit on the basis of Murdoch. We do submit that disentitles the claimant from requiring us to disgorge all of the profits. There's no hint in Murdoch that one asks a follow-on question, such as, well, what would have happened if the claimant had got on with it, or would it have made any difference, or what alternative universes are we dealing with?
And why is that equitable if it wouldn't have made any difference?
Because we would submit that it is, equity says it's wrong in principle for the claimant to sit aside, allow us to take all the risk, and then come along and say, well, I want 100% of the pot.
Well, it doesn't say that in relation to the doctrine of late cheat in its classic form. Why should it say it in relation to this unconscionable delay as an analogous principle?
Because, I'm afraid I'll probably just end up repeating the previous answer, that when one looks at all the cases, I mean, in Clegg, in Murdoch, in none of them, in Warman as well. I mean, in Warman, for example, at paragraph, I'll only give the court the reference, at 559, the quote from Warman is, "The conduct of the plaintiff may be such as to make it inequitable to order an account." Again, there's at least no overt reference to the consequences of that conduct. But that is our primary submission on the point. If, contrary to that, the court considers that we have to show that Mr. Jaffe's conduct had some effect, then our alternative submission is, as I think I said this to my Lord Justice Popplewell on the first day, was that while obviously the court can't reach a decision as to exactly what would have happened, because you don't have the available material, it will be a multifaceted discussion. What this court can be confident of, we respectfully submit, is that things would have turned out differently. And we say that for a number of reasons. First of all, arguing about sums which haven't yet been earned, and in circumstances where on some of the dates we propose, the deal with the family hadn't even yet been done, would be very different, a very different form of litigation, to arguing about sums which have been earned against a contract with the family which has been concluded. So following on from that, second, therefore, we say any proceedings brought at earlier dates would have been very different in terms and in scope, and not least because there wouldn't have been a quantum phase. And third, and perhaps being commercially most realistic.
So there wouldn't have been a quantum phase. Why?
Well, because at that stage, if we'd lost, then there wouldn't have been a separate quantum phase, in the sense that we wouldn't have had the other deals. We wouldn't have arguments about the RBS investment and things like that, because they wouldn't have been there. At the original stage, if Mr. Jaffe had started proceedings saying, "You owe me a fiduciary duty, what you're doing is a breach," that would have brought matters we submit to a head.
You'd have argued not.
We'd have argued not, but hypothetically,
you would have lost.
We'd have lost.
You'd then have said, as you continue to say, in any event, we don't have to disgorge all the profits. Your submission assumes you would then have downed tools.
Well, my lord, the way I would put it respectfully is this. It's one thing to say, we've earned this, the pot has X in it. The claimant is claiming X, and you're arguing about X, and parties take their litigation stances. I would invite the court to look at this, if I may say, realistically, when X has not been earned.
I'm sorry to interrupt you, but it hadn't had it when the proceedings were commenced.
Sorry?
The pot hadn't been earned.
That's what I'm saying, when X had not been earned.
No, not on the hypothetical. In the real world, when the proceedings were in fact commenced in 2016, it was only just about then that the threshold was reached, wasn't it?
But it was clear that very significant monies were coming in. I mean, the other litigation was out there. It was clear that there were going to be very significant recoveries. If one positing much earlier dates, one is talking about a world where, and this ties into my risk point, obviously, the hurdle may or may not be got over. And litigation where you're arguing at an earlier stage, parties do take different positions.
But aren't you, on that hypothesis, trying to close off the litigation before the pot of gold arrives?
In what sense close off?
Well, I think this is the point made against you. That you might then be left to, depending on how you... I mean, in essence, you're saying you have to take the litigation forward at a point when there may be nothing in it for the claimants.
No, the claimant has his position as to what we're doing is improper and a breach of fiduciary duty. At the moment, I'm responding to Lord Justice Popplewell's point, which is to say that we can assume that the stances taken by both parties throughout litigation, if it was started at an earlier stage, would have been exactly the same as in this litigation. And my short response to that...
I'm not sure that is what I was...
in which case...
I was seeking to resist your suggestion that we could assume that things would have been sure that either assumption is something that one can make.
Well, Lord, I do respectfully submit that the most likely conclusion is that things would have been different, whether that's because the litigation would have proceeded differently or because the parties would have taken a different view as to their commercial positions, or whether, of course, if a deal with the family hadn't yet been done, whether some different deal with the family would have been done. I mean, who knows? I'm certainly not submitting that the court can know what would have happened or can decide what would have happened. At the moment, I'm just making a less comprehensive point, which is that the court shouldn't proceed on the basis that what did happen would have happened even if litigation had started at an earlier date. I'm not putting it any higher than that. Finally, I think, my Lord, in the section dealing with reply submissions on the delay point, let me say a word about consequences. My learned friend made a point of principle, which is to say that the court can't find that these dates have any relevance, because the learned judge already decided that there was no break in the sufficient connection between the breach and the profits as at these dates. And we respectfully submit that that is to ask the wrong question. It's a category error. The sufficient connection test is answering a different question. The sufficient connection test identifies, we submit, the relevant universe of profits for the account. So what you're answering when you ask the sufficient connection test is, when I'm taking an account, which of the profits is sufficiently connected to the breach that, all other things being equal, they're part of the account. Delay goes to a different question. Delay goes to the question, which of those profits, which would otherwise be in the universe of the account, is the claimant precluded from obtaining because he's delayed, such that it's unconscionable for him to claim that element of the profits. So the sufficient connection test is not an answer to the delay point. It doesn't preclude the delay point, because conceptually they're dealing with different questions. So, my Lord and my Lady, unless I can assist the court further on the delay point, that's all I was going to say in reply.
Just on that, I think one of the points may be that Warman can certainly be interpreted as being about the sufficient connection or scope. I think you're then seeking to take those principles and apply them arguably in a different way, in a way you say is different, to exclude profits from the account that would otherwise be within them.
Warman is an interesting case. I mean, what Warman does is have some broad statements of principle on which we rely. When I was making my submissions on the first day, I hope I was clear that Warman doesn't deal in terms with what we say is the delay point, i.e. not a full bar to the account delay point, but delay pro tanto. What Warman does, however, is provide the foundation which, when you look at Murdoch, and Murdoch really is the central case which deals with it explicitly on our submissions. Of course, we rely on Clegg by way of background, we rely on Warman, but it's Murdoch and the sections in Murdoch which are central to this argument. My Lords, on the 50-50 point, which, if I may say, got a very thorough analysis on the first morning, so I will make my submissions fairly briefly on it. I wanted to stress one substantive point and then deal with one other procedural point if I need to. The substantive point is this, and it's at this point that the submissions that I've been making and the submissions which my learned friend Mr. Burt have been making, so to speak, mesh in, because on my 50-50 point, as the court will recall from my, I think I called it a waterfall of arguments, the last point in the waterfall is that if the court is against me on everything, i.e. I either don't have a binding contract, or I did have a binding contract, but it was automatically revoked on breach. So where I end up with is I have some sort of agreement, but not an agreement binding in law. The last point was that is the best available evidence of the work and should be determinative of the equitable allowance. That's the way we put it in our ground one. It's subparagraph 5 of our ground one. And of course, that then ties into my learned friend Mr. Burt's submissions. Of course, he's essentially submitting in response to my learned friend, well, you shouldn't go below 25. And my submission on our appeal is that you should go above 25, i.e. to 50. And so that's the way the two chime together. And we were concerned, I'm sure unnecessarily, to make sure the court understood that that is our final alternative submission on our appeal, that the gravitational pull, if I can put it that way, of the 50% non-binding agreement has a real impact. That gravitational pull has a real impact on the equitable allowance, such that 50% is the proper figure. That's the substantive point. The procedural point, which I can deal with if the court wants me to, is to respond to what was called by my learned friend a concession by my learned predecessor, Mr. Cogley. It wasn't clear to me whether this was a point on which the court wanted further submissions. I'm happy to say something briefly about it. What we say is simply this. If one looks at what Mr. Cogley said, Mr. Cogley wasn't saying we are limiting our claim to 40%. He was saying we had limited our claim to 40%. He wasn't making any concession there and then. He was recalling, and with respect to him entirely wrongly, what we had already said. And it was wrong because although there was a reference to 40% in our phase 2 pleading, I'll just give the court the reference rather than go to it. It's core bundle, tab 15, page 307. That's paragraph 16.1. That was a sum that in one of our waterfall of arguments, we were saying Mr. Jaffe should be entitled to on the account. And that seems to us where Mr. Cogley was recalling, because he said we had said 40%, that the 40% came from. It's plainly an error. In my respectful submission, therefore, read fairly, it's not a concession at all. Alternatively, if it is a concession, it's one which, in my respectful submission, I'm able to withdraw, as I said in my earlier submissions, and we do, and we don't understand there to be any prejudice. Indeed, my learned friend's response to, I think it was my Lord Justice Popplewell, was to say, well, we can only withdraw it once we've given a proper explanation as to where it came from. Well, I'm not sure that's actually correct with respect to my learned friend, but if we do need an explanation, that's it. But the starting point is it's not a concession at all. He's just recalling something erroneously. My lords, I did say, my lady, I did say I would be relatively short in reply. Unless there are any further questions from the court, those are our submissions.
No, thank you.
I'm grateful.
By way of reply, I know I have 20 minutes, and I have 8 factors that I want to bear in mind if I can in time. First, Mr. Burt suggested that this is a narrow appeal. As I said in opening, we don't accept that to be the case. We say there's an issue of principle here, because we say in adopting the approach the judge did, she adopted an unfair approach. She embarked on an unauthorised roving commission, contrary to the decision in Gray. Policy behind that position lies in the exceptionality and sparing use of the equitable allowance. So we challenge her overall findings in principle. We also challenge her findings in relation to the individual factors that she identified. Indeed, Mr. Burt referred to the exercise of determining reasonable remuneration, at least as a potentially multifaceted inquiry. And we agree with that.
what we say is that's exactly why it's necessary for that inquiry to take place against the background of a properly identified case, so that the parties can make proper submissions based on evidence that they have had the opportunity to consider and adduce if necessary, so as to identify the factors that are relevant when that equitable discretion is to be exercised. And it's worth remembering that this is not a point in relation to Gray that we've only raised on appeal. This is a point that we said explicitly in our written and oral closing submissions. And the judgment reflects that, paragraph 467 of the judgment. So it's a point that was taken at trial, but the judge nonetheless adopted what we say to be an unfair approach. And it's significant to note that we have criticisms of every one of the indicators identified by the judge. The point we took before the judge was the case that the defendants have put forward has failed, therefore no further inquiry. The judge, instead of taking that into account, looked and undertook a roving inquiry and came up with the factors that she then identified. The only time at which we were able to address those factors and to seek to explain why the factors are not reliable factors was seeking permission to appeal. If those points had been raised at trial, we would have had arguments that we would wish to articulate in respect. If they had been pleaded, or if the defendants had sought to say that they were not going to rely on the exceptionality case of their skill, but instead were going to say what would the market or what would be the value that would attach to this particular service that they provided, we would have wanted to decide what evidence we wanted to call, but that wasn't their case. So we don't say it's a narrow appeal, we say it's a point of principle, backed up by criticisms of the actual approach the judge adopted. That's the first point. The second point is one that relates to the what might be seen, and certainly the defendants see, as the apparent harshness of the overall result for which the claimants contend. And Mr. Burt sought to suggest that it would be harsh to give them nothing at all. And we say, in relation to equitable allowance, that would be as a result of their choice. They did not come to court to argue reasonable remuneration. They came to argue for an equitable allowance based on their unique skill. That was their choice. Litigation favours finality. And again, without seeking to intrude on private grief, that was the position that the Supreme Court adopted. And in Al-Madeni, Lord Justice Dyson at paragraph 21 notes that one of the consequences of the adversarial system is that a judge may be compelled to reject a claim, even if it might have succeeded, if it had been presented in a different way. It's a way to stop uncertainty and potentially real unfairness. And we do say that it is an unfair situation. Moreover, we rely on observations of Lord Justice Newgee in Satyan, where he identifies the risk that a trial can become something of a free-for-all. That's Authorities Bundle 4, tab 31, page 972, at paragraph 35. What Mr. Burt sought to do by referring to the defendant's closing and opening submissions was we submit exactly that. But actually our case goes even further than that, because as the judge found, ultimately, the defendant's case didn't work. Moreover, still in the context of harshness, Mr. Burt submitted that a decision to give the defendants nothing would not have reflected any of the authorities. He said that yesterday, page 179. But that's exactly what happened in Gray, that's what happened in Novation, and that's what happened in the hotel portfolio case that we referred to. So we say there isn't harshness here. Picking up Lord Justice Phillips' comments yesterday in relation to the loans, there was discussion about that this morning. The only evidence that I would add to what the judge found at 455, which we looked at, is that these loans related to loans made in 2009, i.e. before the break, during the period of time where the defendants were working with SCPI. The reference to that is Core Bundle 2, tab 15, page 336. And in fact, what that document shows, and that's part of the defendant's position paper, is that the loans were repaid in 2011 and 2016. So we say this isn't a case where harshness should arise. And indeed, in relation to the URSA threshold, another form of harshness that is apparently relied upon, we say there, as I said in my submissions yesterday, that that was something that the defendants themselves chose to introduce for themselves. And indeed, at trial, that was not a factor that was particularly relied upon by the defendants. The defendants did not say that one of the risks, one of the particular risks that they faced, was that they wouldn't make the threshold. As a result, there was no exploration, whether by way of delay or by way of allowance, as to exactly what would, by factual inquiry, have been established if they had met the threshold or not. So that just simply wasn't engaged with at trial, for understandable reasons. And that's against a backdrop where the defendants knew that the risks of seeking an account was in frame for them. And the references for that is just judgment paragraph 49, 55 and 58. The third area of my submissions relates to the three cases relied on by Mr. Burt in relation to equitable allowances. The first point to note is that all three cases were decided before Gray. We say that they are unreliable guides in those circumstances. Moreover, they are all first instance decisions where the point that we take in this case appears not to have been taken, either before the judge or on appeal. And here, as I've said, the point was clearly taken by the claimants that the case the defendants put forward had failed, and therefore they shouldn't be entitled to go any further. And that's judgment, page 467. And those comments relate to each of the three cases. I'll look at each in turn. Official, which is Authorities Bundle 2, tab 14. If the court is able, not now I'm afraid because of time, but in due course to look at paragraphs 421 to 422, what the court will see there is that the judgment involved a much more limited finding of breach, and specifically a finding that the fiduciary's duties were limited and that he'd furthered his own interests in a very limited and specific way. It was a case of potential conflict of interest, not actual conflict. And in paragraph 421, what the court does, and what the judge did, was considered Guinness as being an arrangement, the Guinness and Saunders as being an arrangement where the fiduciary was placing themselves in a position where they would be in the starkest of conflicts, contrasting that with the position of Dr. Fisher. And perhaps it is actually sensible just to turn up the authority. It's Bundle 2, Authority Bundle 2, tab 14, at page 421. And one picks it up at 421, internal page 1499. And one sees first at F, the judge looking at Guinness and Saunders and saying in that case the arrangement was plainly placing the appellant in a position where, in his capacity as a director, he would be put in the starkest of conflicts. His interest would benefit from a high bid. So contrasting the case of Dr. Fischel with the case of Guinness, then cut down to the sentence that follows the next one. So it is, with respect, easy to see why the court thought it would be wrong to make any allowance at all in respect of an arrangement so obviously inimical to the director's duty. In my opinion, it would also be likely, in many cases, to infringe Lord Gough's principle to award a fiduciary full value of the services rendered. Even shorn of any profit element, fiduciaries would not necessarily be encouraged to hold to the straight and narrow if they were to be properly rewarded for their breach of fiduciary duty. However, in an appropriate case, I do not consider the principle would preclude some reward for services rendered, albeit not compensation representing the full value of those services. And so what we say there is, this is not a case of disloyalty to that extent, contrasting the judge does with the case in Boardman. And what the court then goes on to look at in the following paragraph: do not consider that Guinness and Saunders bars the way. However, any sum awarded must be equitable in all the circumstances. And then, in my opinion, a crucial feature of the case is that Dr. Fisher was drawing his university salary whilst doing this work, and indeed contends that it was an acceptable way of performing his duties. If he had received payment in accordance with his contract, he would have received 5% of the income received from these patients, save after the renegotiated contract, when he would have received nothing, because the cap was apparently reached. I consider that it would be equitable to award the sum in that case. So we say in that case, this wasn't a case on all fours with Guinness insofar as there was no disloyalty. And what the judge was saying was, in a rough and ready way, because what he did could have been done under the contract, he should be entitled to receive what he would have received under the contract. We say that doesn't assist when your ladyship come to work out what the equitable allowance should be in this case. Moreover, as I've said, it was decided before Gray. Then Kingsley, which is an Authorities Bundle 2, tab 19. Again, that's pre-Gray. Again, it's a first instance decision. Again, no point was taken. The allowance itself was incredibly small. It's £2,500 or £3,000 a month, and there's no reasoning by the judge as to how he came to those amounts, save for an apparent acceptance that they were reasonable. Then Akidia, that's Authorities Bundle 2, tab 21, we do rely on paragraph 95 of that decision, which makes clear that the market value is being assessed by the judge on the basis of the evidence that was before him. What Mr. Burt submitted was that the evidence available in this case was no better than in the case of Akidia. But we say that, no, that's not right. In Akidia, there was evidence to show the rate that had been negotiated and agreed by a non-party for equivalent services. Here, the only evidence of rates that the defendants seek to rely upon, we say materially or relevantly, are the 50-50 agreement. And the judge, having found that that was not the proper basis, the judge then went on to look at other factors. My fourth area of submissions relates to Gray. My own friend suggested it was a red herring in the High Court, and that only one piece of evidence was relied on. Well, there was a piece of evidence relied on. The judge rejected the evidence and decided that there should then be no equitable allowance. We say precisely that's exactly what should happen. Indeed, that's what the Court of Appeal then says was the appropriate approach to adopt, because the court says in paragraph 239 that the court is, at first instance, not then authorised to undertake a roving commission. And the word authorised is the word that is used, not entitled, i.e., same thing, not able to do so. But that's exactly what happened in this case. The fifth area relates to cases on the court's approach to pleadings. We say that Sabir and Dink are of no real assistance. Sabir was a case as to whether or not it was a sham or not. Judge reached findings that it wasn't a sham and looked at the evidence. Doesn't assist this case. In Dink, the crucial element is prejudice. And we say we can show prejudice, and we can also show that it was unjust. The sixth point, or the sixth area, relates to pleadings. And we say when the court comes to analyse the pleadings put forward, it is clear that there was no case being put forward on the basis that the judge found. The judge made exactly that conclusion. And then a friend said, well, what they had pleaded was sufficient to capture the case that the judge found. We say, no, it didn't. Moreover, what was the pleading directed at? The pleading was expressly directed at a term of art. It was using the word exceptionality with a particular reason. It was seeking to say that there were exceptional circumstances in this case by the exceptional skill that was being demonstrated.
So what's the term of art is
exceptional.
Exceptional.
Because that is the language used in the authorities to indicate the circumstances in which an equitable allowance will be given. Mere time, skill and effort not being sufficient, usually, to obtain an equitable allowance.
No, in the authorities, exceptional is not applied to the services.
Well, it's
in Boardman and
so
Phillips, the services weren't exceptional, were they?
well, in Boardman and Phipps, they were, one could have said they were exceptional in circumstances where the trustee obtains benefit for the trust, albeit without satisfying the strict rules of equity, obtains through his own special work a considerable profit. And in those circumstances, the court does find that it's exceptional that in those circumstances he should get.
It finds it's exceptional if that is the test, that he should recover, but he's not doing anything that any other trustee wouldn't have been able to do, is he?
We would say when one looks at Boardman and Phipps, I accept some other trustees might have been able to do that, but on the facts of that particular case, the court finds that it's exceptional, and what has been done is exceptional. Therefore, the exceptional equitable allowance should be granted.
Well,
In this case, we say in circumstances where the pleading seeks to rely on exceptional skill, that should properly be understood as not a reference to reasonable remuneration in a wider sense. It is a reference to the particular test in Boardman and Phipps. It is also a particular reference to the nature of the skill that is being demonstrated. It is not saying that there should be a wider, more roving analysis to see whether or not, from all the reasons and all the facts in the case, it might be appropriate to give some form of reward. But that is what my learned friend seeks to say it does, and we submit that that's not right. Otherwise, on Mr. Burt's case, the adjective exceptional is a pointless adjective, and we say it's not pointless because in the context of this particular equitable discretion, it has a meaning and should be given that meaning, and the defendants meant it with that meaning, argued for it with that meaning, and the judge found that they didn't satisfy that test, but then went on to do something else. So that's what we say in relation to the allegation that the sufficiency of pleading. As to the profit share element, I accept our main complaint doesn't relate to profit share. It relates more to the quantum of the profit share. But that's not to say that we don't have an argument about that. Because what we say is, in circumstances where the judge has found that the 50-50 agreement isn't the proper starting point, the question then becomes, what was the starting point? And the defendants, we submit, didn't put forward any starting point because, as Mr. Burt's submissions made clear, all that really was being relied on was indeed the 50-50 agreement. In relation to quantum, the suggestion that at least 50% could include any figure effectively between between 1 and 100 is, we submit, unrealistic. And it is it could be 100 on the claimant's case, so on the defendant's case, because at least 50% on their case actually means 25. We say if there was some contention for a particular percentage of the profit share, that should have been articulated by the defendants. And in the absence of an articulation of what percentage they were claiming for and why they were claiming that percentage, they should not have been entitled to receive that 25%. Moreover, the judge herself doesn't then seek to explain how the 25% is arrived at. It is a figure, we would say, literally plucked out of the air. That's on pleading. In relation to openings and closings, I've made my point already that it's not about, and a trial shouldn't be about free-for-all. But those documents also look at exceptional deployment and those types of evidence. 7, I'll deal briefly with the evidence. We do say that there's more evidence that we would have adduced. We don't say that in all cases expert evidence is required, but in this case, expert evidence, if reasonable remuneration is being sought, we would have wanted to decide whether or not expert evidence should be brought in. Why didn't we? We didn't, because the pleading did not suggest that it was needed. And moreover, when one looks then at the particular factors that the judge relies on, one sees that those are antique in nature. For example, the figures paid to Mr. Rudhadze were paid at a time where he was the heir apparent. So he was a trusted lieutenant of Mr. Jaffe, who Mr. Jaffe thought would then take over if he stood back. That's judgment, paragraph 469b. Moreover, in relation to Mr. Alexeyev, there's an expectation of 10%, but that's not an expectation that in fact came to be satisfied. Moreover, back to Mr. Rudhadze, the 40 to 50% took account of other factors that are identified in the Phase 1 judgment. His involvement in putting together the arrangement for the recovery services, that's Phase 1 judgment, paragraph 5. And moreover, it recognised his ability to assist in the aftermath of Mr. Patakashvili's death. That's judgment in Phase 1, paragraph 128. So that's precisely the type of analysis that one would want to have undertaken with the judge before one decides that one can look to past factors so as to inform the future. But no analysis like that was undertaken. So no expert evidence and no analysis of what had happened in the past so as to inform the future, save in relation to the 50% alleged antecedent agreement, where the judge found that that wasn't the proper starting point. So evidentially, we say there is an unfairness. There is a case that we would have wanted to present, and we shouldn't have been prevented from doing so. And May 2011 would have been then a moment in time on which greater focus would have been needed. Because absolutely the judge said there wasn't low-hanging fruit, but the judge would need then to have assessed what was different then in terms of recruiting someone to do the task, as against recruiting someone back in 2008 to do the task. In 2008, the family was under pressure, so one can well understand why Mr. Houff was seeking to claim large sums of money. But by 2011, the position was very different. And a proper analysis then of the market value or the reasonable remuneration that would have been agreed might have required evidence from the parties, might have required expert evidence. Again, we simply don't know because of the approach the judge adopted. My 8th point relates to factors. And in relation to factors, I can be relatively brief. My learned friend suggested that it's all evidence in this case, but that fails to grapple with our underlying submission that this was a roving commission. Secondly, he said, it's not irrelevant to look back because they all related to the recovery services. But as I've already said, Mr. Rudhadze's recruitment and Mr. Rudhadze's ultimate position by the time he began to get the 40% profit share that he was being offered was because he was going to be Mr. Jaffe's lieutenant. He was going to be the person who would take over. And in those circumstances, one can't satisfactorily look back. And in relation to the other factors, we repeat the submissions that we made in opening. None of the submissions made in relation to paragraph 469A, we submit, explain why that is relevant. That is the fact that they were to do the bulk of the work. B, I've dealt with in relation to Mr. Rudhadze. C and D, we do say are about expectation. And it's worth bearing in mind Mr. Marson's position, that Mr. Marson earned a salary of £150,000 and a bonus of £35,000. That's judgment, paragraph 37. And yet he's been given this very large profit share. That's not a factor that the judge apparently takes into account at all when she comes to look at these particular factors. So we do say those are irrelevant, and we certainly say that E is irrelevant, because it is simply not clear why what Mr. Houff wanted back in 2008 can be a proper indicator of what should be found in 2011, or what should be granted by an equitable court exercising its equitable discretion at this sort of stage. There's been no explanation at all to the 25%. Those are the submissions I want to make by way of reply. If I may just briefly make 2 points in relation to my learned friend Lord Wilson's submissions this morning. First, in relation to Cecil.
I'm not sure you have any entitlement.
Well, Cecil and Byatt.
Cecil and Byatt, all right.
Cecil and Byatt, we say that it is a very different case. It is looking at the exercise of the CPR discretion as to whether or not there are reasonable grounds for extending time to serve a claim form. It is looking at in circumstances where there is a question of a limitation defence arising. This case, a limitation defence was still pleaded, and was then not pursued at trial. So we say that that is not, it's not a case that really assists this court at all. There is, Lord Wolfson referred to the fact that there was large-scale commercial litigation in that case. Answer, so what? But what the court is able to know in this case is that as a result of the actions of the defendants, the claimants had no money to pursue these proceedings. And the oddity of this entire case about what should have happened is that rather than saying the claimants should have started the proceedings earlier, the suggestion is always Mr. Jaffe should have found the money from somewhere so as then to bring the proceedings. Ultimately, once Mr. Jaffe was in a position to have known how the litigation that he was also fighting boiled out, he was able to obtain funding. The judge heard evidence in relation to all those matters, reached firm and clear conclusions. The suggestion that Cecil and Byatt should then form a basis for undermining the judge's findings, we say, in principle, would be wrong. I said I had 2 points. In fact, that was my second point, and those are the only points I want to make.
Thank you. Well, we will take time to consider our judgment. We'll hand down judgment. It will be circulated in draft in the usual way. You all know, but it's important to say it, the recent authorities emphasising the importance of the restrictions on the draft. Returns, please, only of an editorial nature, not an opportunity to re-argue the case. And when you have it, if there are consequential matters upon which you cannot agree, which need to be determined in order to draw up the order, then we'll have your rival submissions on those in writing. Thank you all very much.
Court